Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Ethics class. In this video, we are going to discuss the difference between the same nomenclature or the synonymous words like advocate, pleader, Vakil, muktar, barrister, attorney, and I'm going to explain you. No doubt, even though they are synonymous, every word has got its own definition. All of you should remind yourself that from hereafter you have to address the legal professional as advocate only. Why? Because of the definition given in the Advocates Act. Yesterday, in the class of development of legal profession, I told you the inception of the Advocates Act 1961, from where you have to address the legal profession as advocate. The definition is given in section 2, clause 1, subclause A of the Advocates Act 1961 as advocate means an advocate entered in any role under the provisions of this act. What is this role? Advocate entered in any role. Here in subclause K, role means a role of advocates prepared and maintained under this act. So, role of maybe the Bar Council of India, role of state of AP, role of state of Telangana. Yes, but your name, the name of the advocate should be entered in the Bar Council, Bar Association. Then only you are entitled to practice as an advocate. So, friends, while explaining the art of advocacy, I told you an advocate. So, please remember, advocate is defined as a person who pleads the cause of another, who pleads the cause of another in a court of law or judicial tribunal, because the definition is from England. They call it as a judicial tribunal. Tribunal means equal to court. Who pleads for the cause of another. So please remember, advocate not only pleading in the court, but also he can render legal aid. He can render legal evidence. So this is the importance of the profession of advocacy. So please remember, normally we are under the impression that advocate, he can give only, he can appear before the court. Please remember, he can give the so-called judicial and legal advice also. This is otherwise called as the chamber practice. So please remember, the advocate represents the interest of his client. So, and he strives hard to fight for the right. No doubt, he representing the accused, he tries his best to see that the case is acquitted. If he is representing the state, if he is a public prosecutor, yes, definitely he will adduce the evidence to such an extent on behalf of the prosecution. He will adduce the evidence to such an extent that the accused is connected to the crime and he gets conviction. So this is the importance of the word advocate. So it is a clear statutory definition. You can't go away from it. Therefore, hereafter you have to call the enrolled lawyers as advocates only. Okay, fine. Next we are going to the other topic, pleader. So normally, even though I say that you have to call everybody as an advocate, so even in the courts we are hearing, pleader garu unnara. So pleader is still a nomenclature for the advocate. So pleader means literal sense. A pleader means who drafts the pleadings. You know, according to order number 6, 7, 8. Order 6 deals with the pleadings. 7, plaint. 8, the written statement. So in the plaint, what should be there? Pleading should be there. In the written statement, pleading should be there. Then pleadings. So order number 6, we have to deal with about 20 rules. So pleading should be regarding the facts. So plead the facts but not the sections of law. Plead only the facts. So likewise, the person who prepares the pleadings is called a pleader. And the person who pleads in the court of law on behalf of his client, so he is called pleader. Actually, pleader, I can say, it's a generic term. For all the advocates, pleader is the generic term. And normally, they used to, it is a word used to refer to the pleaders on behalf of the governments. Normally, you may know, according to section 2, clause 7 in the CPC, in the definitions part I told you, pleader, government pleader. So, government pleader means a pleader who represents the cases filed by the state, by the government, and the cases filed against the state. So, he is the government pleader. So, section 2, clause 7 of the CPC 1908, right? A pleader is a government pleader is appointed by the state to perform all or any of the functions. On behalf of the various governments and also the central agencies. So here you have to remember that when once you are appointed as a government pleader, you should not file any case against the state, against the state. Of course, we do file, but we entrust the matter to our juniors or known persons, right? Then third name is Vakil. Vakil Saab. You might have seen the film in which Pawan Kalyan acted very ferociously, and it is a hit also. Vakil Saab. So this is Vakil. Vakil. Please, I told you in the development of legal profession, I told you that the Vakils were the literally the people representing the litigants in the Mughal employees course, because Mughals, they do not know our language. They are from Persia. So whatever they do not know our language. So therefore, the Vakils, they used to take actual representation on the part of somebody and represent them, and they used to get a percentage. They are called Vakils. Still now, the word Vakil is represented by Vakalatnama. What is Vakalatnama? According to order number 3, rule number 4. So it is nothing but appointing an advocate. If you want to appoint an advocate, so the advocate should file the Vakalatnama on which the signature and attestation of the so-called client should be there. So the person who gets this Vakalatnama is called as Vakil. But please remember, Vakils were previously non-qualified advocates. And now the present generation, the word Vakil is totally not allowed. So Vakils were the persons who were actually entrusted by the Mughal employees. The legal profession was existing in a Mughal period. During the reign of the Shah Jahan, government advocates were called as Vakil-e-Sarkar, Vakil-e-Sarkar or Vakil-e-Sharai. So legal aid was provided. Now we have discussed pleader, Vakil and advocate. So another terminology, very common terminology, lawyer. So when once you refer to the word lawyer, lawyer means any person who studied law. Any academician who studied law is a lawyer. So friends, here in this connection I want to tell you, previously there were some colleges which impart the course BGL, that is Bachelor of General Law. That is a 2 years course. Of course, you are interested in the legal studies. Yes, you can study, but you are not supposed to practice basing on that BGL. Yesterday, I told you the case of that magistrate who was appointed, even though he studied BGL, he worked as a magistrate for some time. When once he applied for the post of the so-called special magistrate, the fact came out and he was denied the so-called position. So likewise, so here lawyer means, please remember, a person who is qualified in legal matters and who is licensed to practice his profession. And please remember, lawyer means by law, in law, he can represent any person in the court of law. He can render legal aid. He can render legal evidence, almost equal to the advocate. But since he studied law, please remember, this is a metamorphosis. When lawyer becomes advocate, when you study the law, when you complete the law, you are a lawyer. When you complete the process of enrollment, then you become advocate. So this is the difference, please remember. And lastly, barrister. You know barrister. Barristers are the advocates who studied bar at law in England. Yes, previously in the reign of the mayor's courts in 1726, only barristers were authorized to represent in the civil courts, in the mayor courts, that is in the presidency courts like Calcutta, Madras and Bombay. So at that time the word barrister, but it is a coveted word. So the person who studied law, who studied bar at law in England, then he is called a barrister. He can be a jurist, please remember. He can represent the advocate before the court of appropriate jurisdiction. So normally you will be given some training, but the barrister will be given additional training in evidence, in the law, as well as in the ethics and the court practice, as well as the procedure also. So this is very important. So he definitely tackles the tasks, including the cases, how to take them to the superiors, and barristers are distinguished cadre because of the education. And if at all any provision is there, normally for appointment of judges, the persons who studied in Oxford, in bar at law, definitely they will be given preferences. So because of the higher education, because of the acquiring the higher qualifications, proficiency, efficiency, so many things will be there with the barrister. And last word is attorney. So normally we have got Attorney General who is appointed under Article 76 of the Constitution of India, and we will discuss him repeatedly. Then another word as Solicitor. Attorney General is supported by the Solicitor General. These two topics we are going to discuss separately. Normally this is the nomenclature for the advocates practicing in the court of law. So please throw emphasis on advocates, then Vakils, then pleaders. The another cadre, I'm sorry, I forgot it. Muktars, of course, now it is not there. But Muktars, please remember, even in that Mughal Empire, since they do not know the language, the Muktar were used as translators for the revenue matters. That's why Muktars are called as revenue agents. Of course, nowadays it is not there. So these are all the different types of legal practitioners in India. Pre-British period and present period. Of course, presently you have to call all of them as advocates only. Okay, with this I am concluding. Thank you very much.